Hello and welcome to IGPP Expert Talks. I am Heena Goswami, Editorial Consultant with IGPP, Institute for Governance, Policies and Politics, New Delhi. Today, to discuss the Digital Personal Data Protection Draft Rules released by the Government of India for public consultation, we are joined by Ms. Aprajita Rana. Ms. Aparajita is a public policy strategist and has been involved in policy representations on defining the scope of intermediary liability and data interception in India, recommendations on the Personal Data Protection Bill 2019, and the Non-Personal Data Framework. She is also Shivning India Fellow for Cybersecurity, an affiliate of the Berkman Klein Center for Internet and Society of the Harvard Law School. Welcome to IGPP Expert Talks, ma'am.
Thank you so much for having me.
So, METI released the draft DPDP rules 2025 to operationalize the Digital Personal Data Protection Act. What are your initial thoughts on the rules? Do they align with your expectations or do they raise any concerns in the industry? Your first thoughts.
I think it's a mixed bag. There are certain areas where the industry expected some clarification, which has not been forthcoming. Even though I think the clients we work with, we had told them that the rules will only be issued in respect of provisions wherein there's a specific reference for prescription of rules. But despite that, during public policy engagement with the government, a lot of clients and companies engaged in this space, they expected some clarification on issues like legitimate use, for example. They were hoping for an expansion of what that means, maybe new criteria for legitimate use, similar to GDPR. That has not been forthcoming by the government. And naturally, we expected there to be guidelines regarding parental consent, data breach. These were expected. However, the form in which they have come, we will obviously discuss them in more detail. Some of it is a surprise, some of it is good, some of it is a bit ambiguous. And data localization, of course, is a new addition that has surely concerned the industry. People are surprised because of the fact that this issue had been laid to rest during the very long drawn consultation process that has occurred on multiple versions of the act before these rules came into picture. So the fact that the industry has to reignite that discussion and again prepare themselves for a possible strict localization regime in India, I think that's one of the issues that is a topic of discussion for sure, along with breach and parental consent.
Let's pick up on that theme of data localization a little more. So the draft rules outline regulation for processing personal data outside India. How do you view these provisions and what potential point of contention might arise among different stakeholders, and how could these rules impact the way businesses operate in India?
So it's a dual folded concern, I would say, because localization has been introduced in two different rules. One of them is a broad localization, which could be applicable to simply any entity, as long as the government feels that there is a justification for that. So essentially, it's Rule 12, and one of them is 12.4. Yeah, so one of them is 12.4 and the other one is under rule, I think 8. I think it's 8. I just want to refer to the specific provision. 14, sorry, yeah. 14. So 14 is essentially a very general data localization provision, and the applicability of this would be across all data fiduciaries. The reason this provision specifically is of concern is because it has been issued under a section of the Act, which only identified that data localization will not be required except to countries that may be notified by the government. So what the industry was expecting is that there will be free flow of data and there will be some restricted country list which the government of India will notify in the future. Now, instead of coming up with the list, what Rule 14 has done is essentially they have introduced a very broad criteria. And what it says is that if the government of India is of the view that certain kind of data is accessible to a foreign government or any agency of a foreign state, then that could be subject to additional data localization criteria. So this is, of course, of concern because data localization traditionally has been subject to a lot of debate. To what extent it really helps, the government of India, that has been a subject of debate. For example, there have been many studies on the fact that having localized data is quite contrary to the interest of having a cyber secure environment. Because if you are trying to protect yourself against cyber threats, you definitely do not want all Indian data to be localized in India. One of the primary components of having a very robust cybersecurity policy is that companies and cybersecurity experts, they keep routing data so that it's not very susceptible to cyber threats. So that is, one very technical concern that the industry has been proposing to the government. Then there are additional concerns. You will have to invest in data centers and local hosting in India. Companies will not be able to route and track data the way that they ordinarily do. They'll need to have a separate India policy. And a more geopolitical concern by a lot of BPOs, etc., is that Indian companies who are doing business abroad, there could be pushback in data localization requirements under those jurisdictions simply because, India is requiring that. So it's a bit of a mixed bag. And as I mentioned, the question of whether or not it's even permitted to come up with a rule like this under the scope of the original section, that itself is also something that has been a topic of discussion. And the second localization is more interesting because under Rule 12.4, they have essentially introduced a localization provision that could be applicable to significant data fiduciaries. As of right now, we don't know who these entities will be, but because it's dependent on the kind of data, the quantity of data that they are processing. However, what the government has said is that there will be a committee, and that committee may decide that as part of additional obligations, some SDFs will need to ensure that the data is based in India. So now the concern with that is that they are talking about some kind of data set. So what we can expect is in the future, when SDF's criteria is established, there could be some directive or some order basis which some kind of data set that these SDFs are processing that could be mandated to be localized in India. However, interestingly, this provision also talks about the fact that the personal data and the traffic pertaining to that data, that will also be localized. This has been subject matter of debate because traffic data is arguably not personal data. It is non-personal data because, traffic data, an example of that is what kind of messages, what was the proportion and the frequency of messages originating from Delhi from this date to this date, what area were the messages. So it's more demographic data and it's more pattern-based data. Now, this kind of data is not within the scope of this act at all because, DPDP is a personal data regulation. So people have been concerned that how exactly can, the government regulate and mandate localization of non-personal data under this provision and whether it's even permitted under the section of the law. So as I said, a hotly debated topic, a lot of issues here. Yeah.
Another issue that has been hotly debated, and you mentioned it, is that of parental consent. And one of the significant proposals in the draft is the requirement for verifiable parental consent. But critics argue that this rule poses technical and operational challenges and also raises privacy concerns. And in a country like India, where I mean the kids are much ahead of their parents in regarding digital literacy, and also, I mean, they are overall more savvy. So, is parental consent a necessary safeguard, or is it kind of an overreach, particularly in the context of India?
I think as a principle, as a concept, parental consent for access to internet content is not something that is too conservative or unnecessary. I think both as a lawyer and as a citizen, I would say so because this is an issue that has been discussed globally and many countries have similar laws. So the fact that the government of India has come up with such a guideline and such a framework is something that should be appreciated because it's well intentioned to start with. However, there are concerns with the manner in which it has been introduced. So the concerns are primarily that it is accessible, it is applicable for any child under the age of 18. Now that's an extremely high threshold. As we know, maybe we need to be concerned about children between 13 to 14 years of age and lower. But above that age group, the question of children's agencies comes into picture. How much say do parents need to have in all kinds of content that they're accessing online? And also the question of many children in India, especially in a country like ours, who don't have any parents, who don't have any guardians. Maybe they are accessing, something like a YouTube or some educational website to learn day-to-day things. And who is going to really vouch for and provide consent for these kind of children? So it's a mixed bag because the age group is kept very high in India. For example, in the EU, the age is around 16. I think it varies between 13 to 16. At that age, beyond a certain age, children can provide their own consent. Similarly, in Singapore, Australia, I think also the age is 16. So legislators in other countries are more focused on the younger demographic, but India has a very high threshold, which is why it's a bit of a concern. And it becomes more concerning because the parental consent requirement is applicable for any kind of internet content. So whether I want to see how to, cook something for my mother on YouTube, and whether I want to really access the dark webs of, some Reddit forums, both highly different online experiences, but both of them will require parental consent. So it's worthwhile, if one thinks about it, that whether the government should think of a risk-based threshold, basically outline that what are the risky online experiences that we are concerned about, where do we want to regulate access for children, and perhaps we want to start with that. And depending on how it goes, then we can think about applying it across the internet spectrum. But I think the good thing is that from the examples of parental consent, how you can obtain parental consent and how it can be provided, I think the government has also tried to be a little helpful to the industry, because they've given examples which are two types of examples. One is that the child can come forward and identify that I am a child, or the parent can say that I have a child and I wish to provide consent for my child to access the internet. They haven't said that you need to go ahead and make sure that no child is accessing your content. There is a requirement to do that kind of check, because there is a requirement under the Act as well as under the one of the schedules of the rules, which says that you don't have to seek consent if you are trying to make sure that anything that is detrimental to the interest of a child, that is not accessible. So a simple example of that is like, let's say there is a social media platform and children are accessing that platform. There is some tracking and there is some processing and checking that these kind of websites will be able to do to make sure that children are not accessing the platform. Now, as a result of that, two things will happen. One is that these entities will end up collecting a lot of information, both from parents and from children, which is not based on consent. Essentially, they are trying to satisfy their due diligence obligation to make sure that nothing detrimental to the interest of a child is being processed. Now, the problem with that, what a lot of people in the industry are criticizing is that this means that these entities will end up collecting a lot more information than they need to, simply under the garb of maintaining compliance with some due diligence obligation. Then what happens to this data? Because it's not supported by consent. So one of the things I think that the draft rules, the next version should clarify is that once the purpose is ensured, once you've served this purpose, this data should be deleted, so that the whole objective of parental consent should not result in another negative consequence, that you end up processing and collecting way more data than you actually need. And the second issue, which I think is good for the industry, is that the government has said that you should do some due diligence to make sure that children don't access internet content and anything detrimental to their interests. However, they have not been prescriptive in terms of how you need to do that, because there are some jurisdictions where they have given examples. So, for example, there are jurisdictions where you need to provide, let's say, an ID. I mean, these are the things that have been discussed in other jurisdictions, that in order to prove yourself as an adult or a child, you should provide some government ID. I think it's a very good thing that this is not there in India. And there are examples of AI technology being used by platforms in other countries, wherein simply by me, the way I wave my hand and the way I move my face, you can figure out what my likely age would be. So I think the positive is that the industry is free to adopt their own means. And it's not that you are required to do it in a certain way, which I think allows some flexibility. Because the alternative to that is that they would mandate that this is the way you would need to undertake parental consent. And even if a child does not identify themselves, and even if a parent does not identify himself, you strictly have to ensure that no child is accessing your platform, which I think is a worse off situation. So I personally don't think this provision is as punitive as it was expected. However, the workings of it needs to be clarified and it needs to be deliberated by the government as to whether it needs to be diluted a little bit so that at least children's access to the internet is not completely in the hands of parents or non-entities.
Also, I mean, I feel the government is, I don't know why it's hung up at the benchmark of 18, because I feel there's, phases of growing up. You are a child, you're in this adolescence phase, and then I think by 18 you're a young adult,
Yeah.
right? And if at 18 you can get married, you can vote, and you can also access internet finally. That's
Yeah, that's true. I mean, especially for girls and young adolescents in India, they do access a lot of internet content that could be harmful if parents know about it. So
yeah.
it's a very I mean it's a complex issue, but I'm not sure whether having parental consent for that is really necessary. I mean, maybe between the kids between 16 to 18 can provide their own consent. That is in place in some other jurisdictions.
Now coming to the report, to the clause of reporting data breaches to the Data Protection Board and the data principle to enhance individuals' control over data. How do you assess this requirement of reporting the breaches? Is it an effective measure according to you, or would there be potential challenges in the implementation?
There are likely to be challenges. So, one of the primary issues that I have been discussing with people we advise, as well as public policy experts, is the fact that we already have an existing cyber breach reporting mechanism under the IT Act, under the certain rules, and pretty much all entities are required to comply with that. Now, the DPDP rules, as expected, they have added more flesh to the data breach reporting mechanism that was introduced under the Act. I think the concern here is that the timelines and the risk of, as in the trigger of reporting. For example, they simply refer to any kind of data privacy breach. They don't have a risk-based threshold. In generally under incident reporting framework for cyber and breaches and data breaches, typically internationally there are established practices of there being a risk-based threshold. What that does is that not every incident needs to be reported because sometimes there could be various technical issues, internal issues, basis which, for example, data may not be accessible or it could appear to be lost. There are many things that happen in very complex data processing infrastructures wherein it takes a bit of time sometimes to figure out whether there is even a threat in the first place. So unless you give entities that kind of time and unless you tell them that this is the benchmark beyond which you have to report, I think ultimately if this provision is introduced in this manner, what will happen is that entities will simply mindlessly start reporting incidents to MeitY because naturally they want to be compliant with the law. And my understanding of the objective of these kind of provisions under these data laws in India, the government essentially wants to know how secure is our ICT infrastructure in India, that what kind of breaches are happening, what are companies doing to respond to it, and what is the nature of data that is susceptible to breaches. There are many data insights that the government can gain by having this kind of cyber breaching framework. So the question really is that having this kind of mindless reporting mechanism, is it really serving that purpose? Because entities will comply, but you may not even get to know the real picture because one of the timelines for reporting under this is that as soon as you get to know. Now, as soon as you have knowledge. Now, obviously, one can have knowledge simply by, like a cybersecurity person, employee in your company saying that there has been a breach. But you don't really know enough more than that. But these rules require that as soon as you have knowledge, you should tell the data principal, the data subject, and you should tell the data protection board. At that point, you are not in any position to give anything efficient and anything important of report. However, you have to do that. And then there's a separate 72-hour timeline where you have to give a more detailed report. So our suggestion, and which I think the industry, many stakeholders in the industry also support, is that MeitY could consider a risk-based threshold. Not every kind of incident needs to be reported. There are things that are important, there are things that are concerning, and there are things that will aid, better cybersecurity standards in India. So perhaps have a mechanism and a threshold for that. And the second thing is that maybe lengthen the timelines a little bit. Give entities a bit of leeway to figure out. Especially, another practical issue is that let's say you're a data fiduciary and you're working with a data processor. Maybe the breach has happened at their end. Now you are waiting for this data processor to get back to you, but the data breach reporting obligation is on the data fiduciary. So even in that to and fro, one could lose a lot of time and be unable to provide let's say, a more accurate picture to the government. So these kind of factors, if they are considered, I think it will serve the original objective that essentially very relevant and accurate information regarding data breaches should be available in the industry as well as to the government. Otherwise, also as a user, if you can imagine, if any kind of breach without it being investigated, you keep getting emails from a Zomato and a Google and a YouTube that your data has been leaked, your data has been leaked, you will completely lose faith in the safety of your data by being maintained by entities, which may not be the case because after a week they may realize that actually it wasn't a threat in the first place. So give some breathing space is I think what our suggestion is on this point.
Also, I mean, the biggest data breaches that have occurred on the part of the state.
Mm.
But that is that. What are
Yeah, I
some of
mean, state is exempted, so I think it's different.
what are some of the key gaps and omissions in the draft DPDP rules that should have been addressed, and what would be your key recommendations based on these draft rules?
I think I'll answer these questions together because they're related. So surely one of the key gaps is that it was expected that there is a section under the parental consent provision wherein it says that some kind of data fiduciaries will be allowed to process data of children depending on, by some established criteria. So a lot of entities are expecting that the government would have provided some insight on that so that whichever entity has a very good and reliable, verifiable consent framework, they can make use of this exemption or a little bit liberalization. So we were hoping that there would be some clarity on that. It was also hoped that there would be some clarity on legitimate use, but that has not happened. So I feel like on the second point, the ship has sailed. I don't think that's going to happen, but at least maybe on the first one, it would be helpful, especially since the whole issue of parental consent in its current form is being debated at length. And other than that, just following up on the points I've mentioned, I think having a more graded risk assessment for cyber breaches, a consideration of whether there should be some kind of platforms that would be subject to the parental consent requirement, rethinking the need for data localization, or perhaps explaining what kind of data localization on what kind of data and which kind of entities it will be applicable to. Because currently the provision is it's a power tool, in the hands of the government, which can be used whenever. So that leads to uncertainty. If the standards are clarified, then at least the industry knows what to be prepared for. I think these kind of issues would be helpful. So our key recommendation would be to essentially introduce these kind of nuances in these provisions so that it adds a bit of legal certainty. It gives clarity to the entities that, the government has, because some of the provisions have been issued under sections wherein the rule-making part does not exist. So, an example of that is the reasonable security measures. There is a rule that talks about the kind of minimum reasonable security measure that should be issued. However, there is no corresponding section for that. So, these kind of provisions, if they are recalibrated and rethought by the government, I think that would give the industry more comfort. And but the good thing is that there are multiple consultation sessions that have been taking place by MeitY. So it does seem that the regulator is quite open to hearing feedback, and they are having a very real consultation process. We don't hear any responses, to many of the concerns that people raise, at least at the larger forums. But I'm hoping that in the closer groups, there is a lot more, at least a to and fro conversation on where the updated version of the rules will go. So primarily these are the meta issues where we feel that most of the people in the industry are going to submit their comments, and so will we.
Thank you so much, Aparajita, for joining us today and this wonderful discussion on the draft digital personal data protection rules. Thank you very much.
Thank you. It was lovely to speak with you.